Judgment in the matter of Tianrui International Holding Company Limited against China Shanshui Cement Group Limited.
This appeal concerns the circumstances in which a minority shareholder can sue a company in which it holds shares, where the directors of that company, in breach of the fiduciary duties which they owe to the company, make a decision which is targeted against the shareholder's enjoyment of the rights attached to its shares. In this case, it is alleged, but yet to be established as a fact, that the directors issued shares to parties connected to majority shareholders acting in concert with the improper purpose of reducing the proportion of shares held by the appellant, Tianrui, and therefore reducing its voting power within the company, which I will call CSCG. I emphasize at the outset that the facts on which the board determines the legal issue are only assumed facts. CSCG is a holding company registered in the Cayman Islands in which 4 large Chinese companies engaged through their subsidiaries in the production of cement in the People's Republic of China have invested as a joint venture. Tianrui's allegation is that the directors of CSCG, at the instance of 2 of the principal shareholders, have sought to reduce Tianrui's 28% stake in the company below 25%. This would remove Tianrui's negative control, that is, its ability to block special resolutions at general meetings of the shareholders. It's asserted that this was done in order to assist the majority shareholders consolidate their control over CSCG. Tianrui brought a personal action against CSCG, challenging the allotment of shares to the connected parties. CSCG sought to strike out the action on the basis that Tianrui had no personal standing to make the claim. CSCG's challenge is that the action is an abusive process because Tianrui does not have standing to sue it, i.e. CSCG, for what it claims, for what are claims arising out of alleged breaches by its board of the fiduciary duties which the directors owed to it, CSCG, and not to Tianrui. At first instance, Mr. Justice Siegel in the Grand Court of the Cayman Islands rejected the strikeout application, holding on the assumed facts that the minority shareholder had a personal claim against the company and that the appropriate remedy was a declaration that the allotment and issue of the shares was unlawful. The Court of Appeal of the Cayman Islands overturned that decision. They held that an aggrieved minority shareholder had no personal right of action against a company for the diminution of its voting power caused by the issue of shares by the directors in breach of their fiduciary duty to the company. The court reasoned that the directors owed those duties to the company. The shareholder could only make a claim on the basis which was consistent with the rule in Foss and Harbottle, or with the exception to that rule that there had been a fraud on the minority. I should explain that the so-called rule in Foss and Harbottle comprises 2 principles. The first, called the proper claimant principle, is that when a wrong is done to a company, such as a breach of fiduciary duty owed to it by a director, only the company and not an individual shareholder can take action. The second principle, called the majority rule principle, is that the will of the majority of shareholders of a company should, as a general rule, prevail in the running of the company's business. A majority of shareholders can usually ratify breaches of duty or irregular acts by a company's directors. The exception to these principles, which is often called fraud in the minority, is where the wrongdoers are themselves in control of the company, and in such circumstances the law may allow the aggrieved shareholder to bring a derivative action on behalf of the company in whom the cause of action is vested. The law, nevertheless, has long recognized that a shareholder has personal rights attached to its shares which it can enforce against the company. Such rights include the right to vote at a general meeting of shareholders or the right to insist that a resolution is passed by the required majority of shareholders. The central question in this appeal is whether there is a juridical basis for a shareholder to assert a personal right where a company's directors have acted for an improper purpose to the detriment of that shareholder's ability to exercise the proportionate voting power attached to its shares by the deliberate dilution of its shareholding through the issue of new shares to the connected persons. The board concludes that Tianrui's appeal should be allowed, holding that a shareholder has a personal right of action against a company where the board of directors has allotted shares for an improper purpose and has negatively affected the shareholder's enjoyment of its rights. Tianrui's writ should therefore be reinstated. In the judgment, the board explains its reasoning. The registered articles of association are a contract between the company and its shareholders, as well as among the shareholders themselves. Shareholders receive a bundle of rights attached to their shares, which they can enforce against the company. The power of directors to allot and issue shares, which is conferred by the company's articles of association, is a fiduciary power which the directors, as the company's agents, must exercise for a proper purpose. It is a necessarily implied term of the corporate contract between the company and its shareholders that the director's exercise of such a power will only be valid if the directors act in good faith and for the benefit of the company as a whole and for the purpose for which the power was conferred. If the directors, as the company's agents, have deliberately exercised such powers with the aim of allowing one group of shareholders to take power at the expense of another, they will have placed the company in breach of that implied term of its contract with the aggrieved shareholder. That implied term in the corporate contract is the juridical basis of Tianrui's claim. On the assumed facts, the board of directors has deliberately deprived Tianrui of its negative control of CSCG, interfering with its rights as a shareholder to have a say in the collective control by shareholders of CSCG's affairs. That places CSCG in breach of its contract with Tianrui. The fact that a majority of shareholders could theoretically ratify an invalid allotment of shares does not make it valid. There would need to be an actual ratification, and if majority shareholders seek to use their power to act by majority, they may be constrained by the equitable principle that they may not do so by oppressing a dissenting minority. The board will therefore humbly advise His Majesty that the appeal will be allowed.